Hey, Paul here again, and in this video we're going to address who should be the administrator of an estate. Okay, so I use the word administrator intentionally because sometimes people die without a will and the family has to go through the court process because things are frozen, and the family has to hire lawyers, go through the court process and have a judge oversee that administration of the estate so that things get handled right and ultimately the remaining assets get dispersed to the heirs in the proper amounts and proportions. And so when somebody dies without a will and the judge has to appoint that person to handle that, that person's called the administrator. Many people call the administrator, they call them the executor, but the executor is that person who was named in the will to be the executor to oversee all of that. We're talking about a circumstance here where somebody didn't have a will and a judge has to appoint somebody. Who should that be? Okay, a couple of housekeeping items. It's kind of different for me today. It's a Saturday morning. I didn't throw on my collared shirt, my button down that I usually, one of many button downs in the closet right behind me that I use for these videos. I said, what the heck, it's Saturday. It happens to be the 33rd wedding anniversary of me and my wife, Amy. Feel free to say congratulations to me and Amy in the comments below. We're gonna have a good dinner this evening. At this point, we're in a situation where our restaurants under the coronavirus partial opening are only, I think, 25% occupied or something like that. We're still trying to figure out what we're gonna do to celebrate that. Okay, but I did want to make this video. It's an important topic. It comes up a lot, came up a couple of times this week in my practice here in Louisiana, so let's just jump right in. Okay, so now I did another video that I'm going to link you to up there that says who can be an administrator. Not just anybody can be an administrator. You have to meet one of the groups of people who can be an administrator. Like I said, it'll be linked above. But this is really focused more on who should be an administrator. All right, so let's just cover some basic principles. It's usually one of the heirs or at least someone who has an interest in seeing this estate settled to completion. So that's kind of basic. Also a key here is if the deceased lived in a state that allows for what's called an independent administrator, you always want someone who all of the heirs will sign the appropriate agreements to allow that administrator to be an independent administrator if your state allows independent administration. What does all that mean? Well, if your state allows there to be an independent administrator, then you can get an administrator appointed, and that administrator can take many routine actions in settling the estate, like paying estate debts, selling estate assets like homes and vehicles. If that administrator is an independent administrator, they can take those actions independent of court approval or without having to get a judge's permission every time they want to take an action as they settle the estate. So it's easier to get estates settled when that administrator is an independent administrator. So one of the basics is you want to make sure that you have an administrator who all of the heirs agree and will sign the paperwork to allow that administrator to be an independent administrator. Now, let's go into a little bit more in depth about what are some of the qualities of the ideal administrator. So one, I would say, is an excellent working relationship with all of the heirs and has earned the trust of all of the heirs and all of the parties. If you've got an administrator who has the trust of all of the parties, then it's likely that all of those parties are willing to sign the agreement to allow that administrator to be an independent administrator. They trust that person. And those parties are also unlikely to demand all of these accountings that heirs have the right to demand as part of the estate settlement. But when heirs start demanding that the administrator supply all of these accountings, it just adds to the delay and expense of the settling of the estate. So another quality I'd say is an administrator who's just quite frankly organized and gets things done. So there's all kinds of, depending upon the assets in the estate and the circumstances, there's a lot of stuff that needs to get done. You got to deal with perhaps a final income tax return. You have to deal with the financial institutions where the deceased had accounts. You're likely going to have to sell a home or other real estate, deal with realtors and purchase agreements and closings, and cleaning out properties and all that kind of thing, getting them ready for sale. In addition, dealing with lawyers, communicating with all of the parties and kind of keeping them satisfied. So somebody who's organized and gets things done is a great quality for an administrator. Somebody who's honest. The radars go up when an administrator isn't forthright with all of the parties. These parties are thinking, wow, we got this administrator in charge of this estate. There's $100,000, there's $1 million, there's $8 million of assets in the estate. That administrator just lied to me about something. What else might they be lying to me about? I'm getting suspicious. I don't trust them. I think I need to get a lawyer and pursue my rights to make sure that administrator doesn't do anything that they shouldn't be doing. Now, when an administrator is honest, transparent, discloses all of the transactions, all of the records, leaves nothing to chance, answers questions, forthright, nothing done behind people's back, you're likely to have a scenario here where that can go about as well as it can be. The whole idea here is we just want a scenario where all hell doesn't break loose. Because when you're settling an estate and all hell breaks loose, then you get to a scenario where, it may be a scenario that would have taken 6 months to complete if, things go amicably and records are well kept and things are transparent and there's no real adversarial issues. But when, quote, all hell breaks loose in the settling of an estate, you can take one that would have taken 6 months to settle and it could take 6 years or more to settle. And at the end of that 6 years, there's no more assets to divide because they were all spent with all of the parties, getting their lawyers and going through the court system because nobody trusted anybody else and there was lots of allegations of misappropriation of funds or whatever the case may be. So that's why that honest and transparent administrator can really earn the trust of everyone by doing things the right way and eliminate all of that hell breaking loose, for lack of a better term. And then maybe another, when you have the ideal administrator, this isn't a requirement, but it helps if that administrator is, I'll call it local. Dad died, he lived in New Orleans, Louisiana, had 3 children. One of the children lives local with dad in New Orleans. The other 2 have moved out to Florida and Texas. It doesn't have to be that New Orleans child who's the administrator, but if it is, it's probably convenient because that local administrator is going to have to deal with issues that I mentioned before, things like selling dad's home, cleaning it out, dealing with the realtor, dealing with purchase agreements, dealing with listing agreements, dealing with closings, dealing with potential buyers. Perhaps that administrator may have to sell 1 or more vehicles of the deceased. So they've got to deal with local buyers and Office of Motor Vehicles and local lawyers, and they've got to deal with all the financial institutions that dad had, and some of those might be local as well. So once that administrator gets the appropriate court orders, they can go visit the financial institutions and get business done that way. It doesn't have to be a local administrator, but when it is, it's kind of an ideal scenario. Okay, so let me give you a couple examples. Let's say, and again, we're talking about here where somebody, I hate to be blunt, but somebody's dead and they didn't have a will. And so now we have to get an administrator appointed by a judge. And so let's say it's just a scenario where a parent dies without a will and his estate is going to his 4 adult children. Parent's not married, maybe he's divorced, maybe his spouse had died, but that parent does have 4 children, and under the laws, that apply when that parent did not have a will, wasn't married, but had 4 children. Everything goes equally to the 4 children. It's typically a scenario where maybe the 4 children get together and they all just agree, you know, let's get Bobby to be the administrator because he's local, he's been taking care of Dad's stuff, he's been paying Dad's bills, he's most familiar with it. Everybody trusts Bobby. Let's name Bobby as the administrator. All of the 4 of them sign all of the appropriate agreements to allow Bobby to be the independent administrator. They get with the lawyers. They go get, file all that stuff at the courthouse. And the lawyer sees that all 4 heirs have agreed to allow Bobby to be the independent administrator. The judge will sign that court order, and then they're off and running. So that's a typical scenario. Now, I dealt with a scenario just this past week where, a mom died, was sick, left 3 adult children, but those 3 adult children were all in their, early 20s. And they're having a tough time with their mother's loss. So the deceased's sister just wants to help out in any way she can. So she's going to be the administrator. All the children are good with it because that sister, the aunt of the children, she just gets things done. She's organized. She's already met with a realtor to sell the house. The aunt just wants to try to preserve as much property and as many assets as she can for her nieces. And so it just so happened in that circumstance, the 3 children were like, great, we want our aunt to handle it. We trust her, she's gonna do a good job. And the 3 children aren't burdened with having to deal with all that stuff in addition to the loss of their mother. Now, sometimes you'll have a married person who passes away, and if they didn't have children, if they didn't have children, then here in Louisiana, their community property would go to their spouse, their separate property would perhaps go to their siblings. Or if they did have children, just quickie version here, surviving spouse would inherit what's called the usufruct, and the children would be the naked owners. So it's typical when a married person dies for their surviving spouse to be the administrator, and all of the family members agree and sign off on all those agreements to allow the surviving spouse to be appointed as the administrator by a judge. You do get the occasion often when maybe a couple got married and lived for many, many years, and the first spouse died, and that spouse, was 85 years old, and their surviving spouse was 90 years old. Sometimes it's more appropriate than for maybe one of the children of that marriage to be the administrator, just because it's easier for them to get things done. They all agree, they all sign off on it, they're well on their way. So anyway, that's kind of decision number 1. When somebody dies without a will, if their estate warrants getting an administrator appointed by a judge, there's 1, who can be an administrator, and then 2, who should be an administrator. I hope that helps. The administrator is likely also to be the type of person who would smash the like button after they watched this video. And if they haven't already subscribed, they subscribe to my channel as well. Thought I'd get that in there somehow. We'll see you next time. Paul Rabalais here.